Today we are discussing inspiration versus infringement, discerning creators' copyrights and responsibilities. You know how they say imitation or copying is the sincerest form of flattery or a compliment that you can pay someone. Now, I'm afraid that's not how the Copyright Act sees it. So without further ado, let's welcome our August panel for the day. We have with us Tarika Pillai, partner Oban & Associates, Subhash Patoria, partner L&L Partners, Dr. Prashant Pratap, partner Pratap & Company, Vindhya Ismani, joint partner Lakshmi Kumaran and Sridharan, and Nehal Nikhil Wagle, legal executive, Quintify Analytics Solutions. I'm your host, Asha Mori, managing editor of BW Legal World, hoping to get as many insights from our experts in the next hour. So experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation with our panelists. Panelists, very quickly, could we have a brief precursor in under a minute or two to your thoughts on the explosion of content in the current age of internet and metaverse in the arts, music, the film industry, YouTube, Instagram, or what we colloquially call the WhatsApp University? How do you see inspiration versus infringement panning out? We will start with Vindhya. Vindhya, your opening comments.
Thank you, Ashima, and thank you for having me as part of this discussion, a very interesting discussion at that. I think personally, inspiration is something which is prevalent in any work that one creates, whether it's in the film industry, whether any art industry. And because of the copyright law, one has to be mindful as to where the inspiration stops and where the copying begins, because copying is infringement, can amount to infringement, and is illegal and unlawful. So specifically in the film industry, I think we've had a mixture of facts which help today for a lawyer or any person, any layman to understand, what is inspiration and versus what is infringement. Now, when you were talking about inspiration, the idea behind that is ideas, themes, plots, they're all common to everyone. It's there in the public domain for everyone to take inspiration from and work on it. But the moment someone's idea is expressed well enough, then if you're going to copy that, that's going to be stepping into the realm of infringement. Now, courts have developed many kinds of principles and doctrines, right from the R.G. Anand case of the Honorable Supreme Court of India. We've had principles being developed to the recent case of a Bombay High Court, where courts have come up with the principle of extraction, where they're trying to extract the copyrightable expression versus the non-copyrightable idea, and then determine whether there is infringement or not. So today, I hope to be discussing some of these case laws to give you a sense of how courts are, dealing with these, because everyone's going to say everything is an idea at the end of the day, but then we have to discern what is an idea and what is an expression. So this will be my attempt today through the course of this discussion, and looking forward to all the other experts also with respect to their respective industries. Thank you.
Right. Thank you so much, Vindhya, for those lovely comments. Tarika, coming to you.
Thanks, Ashma, and it's indeed an honor to be part of this panel. So in a world where, ideas are being brewed every second, content is being created, every place you go, every person you meet, inspiration is being derived, it's really difficult to actually come back to where the source is and where the origin of this ideas are coming from. Now, everybody wants to think and do something unique, and they feel that they're doing something unique and may not even be aware of the fact that they may be infringing someone's rights. So, I feel I will just lay emphasis on what Picasso said, that nothing is original anymore. Everything has been done to quite an extent before. So in today's discussion, what I will be dealing with is the tests that have been held by courts in India and the US, which is the substantive similarity test, where the determining factor of what exactly could be similar, what wouldn't be considered similar, has been laid down. So there are quite a few case laws, and as Vindhya had mentioned, R.G. Anand is honestly, I feel, the most important case law for this topic today, where certain determining factors were laid down. So I'll be diving into that today and hope to bring some light into what can be considered infringing and not.
Right, certainly. Thank you so much, Tarika. Dr. Pratap, coming to you. Your thoughts.
I would like to thank you for having me here today. And my thought, I would like to quote Nina Paley, who's a US photographer, and she said that copying is actually the engine of cultural, progress. And she actually took like 482 photographs, and over the years in the Metropolitan Museum in US, and she saw that most of these things, the theme is the same. It's a little change here, a little change there over the years or 1,000 years history. She went through all the photographs, and there's a video. I cannot share it because we don't have that much time, but that covers the whole thing. So yes, I definitely agree. Copying is been there with us for a very long time. And now with the advent of the internet and YouTube and Instagram, it has become, even more opportunities for people to express themselves and to reach out to a bigger audience, a newer audience, which also gives more opportunities for things being copied and people driving inspiration. So I intend to restrict my segment to the art over the years and photography and a little bit of fashion. So that's going to be the constituent of my segment today.
Right. Thank you so much, Dr. Pratap. Looking forward to it. Subhash, coming to you for your opening comments.
Thank you, Ashima. And well, whenever somebody says, I'm truly inspired, so as an IP lawyer, I always find a cause of action arising. So I think what we are discussing here is what amounts to an inspiration and what is truly inspiring, where you enter into the domain of substantial similarity. Mm-hmm. So, today's discussion, we'll have a lot of understanding of the law, a lot of, case laws discussed. I would stick to very fundamentals of copyrights, the fundamental of copying, the purpose and intent of creativity. That is very important to understand because copyright law is not as stringent as patent law or trademark. We need to understand that it allows people, it's a welfare legislation which allows people to get inspired. So in the law itself, you will see that while there is infringement, there are exceptions to infringement. So when I'm dealing with the fundamental of law, I would also take, certain examples from the case laws, from different issues or dispute, whichever arisen, trying to distinguish and trying to create sort of a resolution or solutions where whether you inspire, whether that is an inspiration or it amounts to infringement.
Right.
I think that's about it.
Thank you, Subhash. Looking forward to it. And Nehal, your opening comments.
Hi, everybody. Thank you, BW Legal, for having me, Legal World, for having me here. So as part of, it's an honor to be part of this discussion. So I would like to say that in today's world of internet age, where the data is extensively available, people have started living under a misconception that everything that is available on internet is free. Free from cost, free from any title, free to be utilized in any manner without being held responsible. As a result, the line between inspiration and infringement or plagiarism is becoming blurry day by day. I think if there are any bloggers or YouTubers in the audience, they would probably connect with me over the fact that there have been many instances where they have been accused or of content violation or committing an act of plagiarism. So here I will recollect that few days back I had heard a comment going around social media that some young Indian bloggers were accused of committing plagiarism when they had just taken an inspiration from a global creator to develop their video content. Now in this discussion today, I would like to highlight this thin line that exists between what is called as inspiration, work derived from inspiration, from what is a copyright infringement or what is just a plagiarism.
Right. Thank you, Nehal. Thank you so much for that. Let's start this discussion again, coming back to Vindhya. Taking from what you alluded to in your opening comments, Vindhya, could we have the lay of the land on what is inspiration, what is infringement in the eyes of law?
Thank you, Ashima. I think I'd like to begin this by stating that without going into the specifics, just to understand, copyright law was never intended, like Subhash just mentioned, that it is a welfare legislation. While it has a negative right, it also has a positive right. That is, you are free to exploit your work in the way that you choose fit. The negative is only that your specific form of expression should not be used by anyone else to your detriment. So that is what the negative aspect of it is. But the primary focus is the positive aspect that, there should be a freedom of ideas, freedom of concepts, freedom of themes. All of this is free for everyone to use. Now, specifically applying this concept to the film industry, now we see themes and plot lines. Now, all of us know, in fact, we joke about how all Bollywood movies come down to the same theme at the end of the day: boy meets girl, rich boy meets poor boy, rich girl meets poor boy. Or, these are themes or these are ideas which are free to all. So no one creator can stake monopoly over that. And to give you an example of a couple of cases, for instance, there was an early case of the Delhi High Court where a particular producer came up with the idea of Swayamvar as a reality TV show. Mm-hmm. Now, you would all know Swayamvar is something which is there in public domain, right? We've known it from the Ramayana, from our mythical ages, that a woman chooses her match from amongst, a list of princes or, kings or whoever. And now this person decides to adopt that into a reality TV show. Then there comes along another person who comes up with a similar concept called Shubh Vivah. Now here you would think this is, just a theme. Swayamvar, it's common to trade and, it's commonly available to everyone. It's commonly known. But then the court injuncted. The court injuncted on the basis that here was someone who had substantially flushed out the theme into a reality show. So the idea of expressing that concept of a Swayamvar through a reality show was done by someone. Therefore, that was expression transcending from a mere idea. And therefore, that should not be, copied by another one. And therefore, it was held to be infringing. Whereas, on a similar line, if you see, there was another case of a show called Bital on Netflix. And there was this particular show was sued by another person claiming that they had the monopoly over another script or another show based on this similar concept of Bital, the story of Bital that we have heard. The court said nothing doing. There's no infringement here because this is a mythical concept which is very well known, and it's an idea that's common to everyone to adopt and to flush it out in different expressions. So there is no one specific set of rules or a parameter or a standard that can be applied, that's going to be applied in a straitjacket formula. It's going to be depending on the cases, how the courts are going to interpret. And in doing so, the courts will look at a couple of factors which are very important to look at, which is that how was this person, how did this defendant, the person who came later, how did he get to know of this? Was he inspired by, when I use the word inspired, did he have knowledge of the previous work? So that's going to be a key factor that the courts will consider. In most of these cases, the scripts were, given to the later production houses. So those are factors that the courts will consider when looking at these questions. To give you another example where there were divergence of views, there was one case where a scriptwriter sued the producers of Dhoom 3, for having a similar plot line. The plot line being that, there are twins, of course, which is revealed later. There's a magician father who commits suicide and, all of that. So there was this story which had similar features. But the court said that, these are themes or ideas which are similar, but there are many differences in the way the idea is flushed out. Therefore, no infringement. But there was another case where the court held, for whatever reason, that the concept had been flushed so much into an expression that you have copied even the expressions. The plot lines are so similar that they deserve to be protected because it is expression and not mere idea. So that's where the court comes up with this doctrine of the notion of extraction, where the court attempts to extract what is protectable copyright work, so which amounts to an expression, whereas what is merely an idea or a theme or a concept, which is not entitled to copyright protection. So the court is doing a delicate task of balancing these competing rights. And it is going to be challenging for the courts, and it's not going to be easy. We're never going to have, one landmark Supreme Court judgment. We do have the RG Anand, which is just giving us broad objectives, but it's not going to give us hardline stances that, is just going to be applied and then, determined. It's never going to be that. The facts and circumstances are going to vary across the board. Now, coming back to the point that I mentioned where the courts look into the factor as to how did the defendant come to know of the previous work. Now, that is interesting in the recent, the Ed Sheeran Shape of You case. So obviously that's not about cinematograph films, but I'll just be touching on that because as we all know, Shape of You was a massive hit in 2017, crossed all records of the most viewed music video. And there was an allegation by a lesser known, music producer and company. They said that the OI hook in the song is copied from their song OY. And, the court goes into meticulous details. This is a case from the UK court, and the High Court goes into meticulous detail as to how the notes are and, what kind of music notation is involved and all of that. But in all of that discussion, the court also bases its final finding that Ed Sheeran did not copy. The court bases its final finding on the fact that the defendant had not proved to a sufficient level that Ed Sheeran had known of the previous work or that he was aware of the previous work. So that becomes an essential question because we were earlier discussing, Ashima and I were discussing that, today I just decide to do something. I don't even know. Sometimes I'm not taking inspiration from something particular. I do something and then I end up finding that it's inspired from someone else. So this becomes, a very important factor to consider whether the later work was aware of the previous work. I think that becomes a factor when the courts determine this issue. So my final words on this is just to complete this session is that there is no straitjacket formula, but we need to understand that the court will discern with all these secondary factors as to whether it is mere inspiration or whether what you have actually copied is just the idea or the theme or the concept, or whether what you have copied is a original expression of another person. It is this determination which the court has to do at the end of the day, and the court will look at all kinds of factors as to whether you were aware, how did you get to know, is the previous work so prevalent that it is but obvious that you would have been aware of it. These are the kind of factors or considerations that court will do before, of course, applying the tests of substantial similarity, substantial copying, and all of that. So it's going to be interesting to see how courts in India will deal with more of these nuanced concepts as and when the facts and situations arises.
Right. And Vidya, interestingly, you took a example of a movie, The Magicians and Twins and all of that. When we as audience see some of these movies and TV shows or something, there's an instant recollection. This is based on the plot line of XYZ. Correct. Now, is that taken into consideration by the courts that, it's such a popular, like you said, if the person is aware of it or not, was it a popular enough artwork? But like you said, in that, particular case, the court probably held in favor of the Doom 3 movie.
Yeah.
Now, how do you then decide that, it's something which is generally seen as, somebody would draw a parallel immediately that, this is something that they're taking from that movie. But where does the thin line between really stealing that exact idea and, making some of it, your own? How do courts really go into that?
No, so depending on where the facts and circumstances are. So if the second stage, of that you knew of the work, that being obvious, for instance, it's something so popular that you would have known, then the courts go into the details of, what are the similarities and what are the dissimilarities. Now, are the dissimilarities very minor, or are the dissimilarities going to the root of the matter that, the actual work, is there dissimilarities in the actual core of the expression? Just to give you an idea, there was in the UK, there have been a couple of cases where the Da Vinci Code was, the producer of Da Vinci Code was sued by authors, because they said that the concepts of the Holy Grail has been copied from our books. The court said, the concept of Holy Grail or the Grail legacies, as you call it, is very well known. It's historical fact. If some were to call it a fact, it's close to, facts in the history rather. Yeah. We can dispute as to its accuracy, but it's there. And so, there is no concept of claiming a monopoly over the Grail legacy just because you've expressed it in your book. Similarly, many would be surprised to know that J.K. Rowling was sued for the Harry Potter book. I think it was The Goblet of Fire, if I'm not wrong, by another author saying that, it was her book on a wizard boy. So, that it was similar. But the court goes into the expression, merely because there was one wizard boy in your book and there is a wizard boy in the Harry Potter book. That does not mean that's just a theme. That's just a concept. But the way Harry Potter's, the universe is expanded and is expressed is a novel work. It's an original work. And therefore, there is no copying. To give you another instance, I mean, if you were to say, all the cop movies, whether it's Dabang, whether it's Singham, they all have a central cop who has shades of gray, not necessarily heroic shades of gray. I mean, if someone was to, monopolize that, then, we'd have no more cop movies. I mean, Suryavanshi, the recent one, we'd have no more cop movies then. So, I think the line is to see where the similarities end and where the dissimilarities begin. So the court has to go into minute details. It has to go into that kind of details. Once it is established that, the defendant was aware of the plaintiff's work, once that is established, you have to go into this detailed analysis and you have to discern it.
And I think that's what even Tarika, mentioned in her opening comments. So Tarika, taking this forward, thank you, Vindhya, for your session here. And Tarika, coming back to you, the principle of substantial similarities, something that you mentioned. Could we have more on that, and how do courts really go into these matters?
Yeah, thanks, Ashma. So, I mean, as a start, let me just briefly define what, in my words at least, inspiration and infringement are. So I feel an inspiration is like a catalyst, a spark, a motive that there is more or less, which creates like a driving force for someone to create something. In simpler terms, it's that eureka moment where you feel, hey, even I can do this. Whereas an infringement happens when you borrow someone else's thoughts or ideas, refer to them as your own, and do not give them due credits. Quoting someone else as a reference point of view does not mean infringement, but if you're miswriting the source where you took it from, that may make you liable for infringement. So in India, there are a lot of, the Delhi High Court, the Bombay High Court, and of course the Supreme Court did consider this test, but the test was actually, formed by a US court, which is a standard test for substantial similarity, which is also known as the ordinary observer test. Now, the test asks whether an ordinary observer, unless he set out to actually detect the disparities between the works, would be disposed to overlook those similarities and consider the aesthetic appeal of the work instead. So as Vindhya had mentioned, in R.G. Anand versus Deluxe Films, which was at the Supreme Court, while adjudicating upon, the infringement that was happening in the screenplay, they adopted the ordinary observer test. This test was, as mentioned, laid down by an American court in Daly versus Palmer, which states that if after watching a movie, an unmistakable impression is made on the mind of an ordinary viewer or a reasonable man that it is a copy of another, it would be considered infringement. In fact, the Delhi High Court as recent, I wouldn't say recent, but in 2012, in the case of 20th Century Fox versus Z Telefilms, also stated that infringing material must be looked at individually, then as compared as a whole. If the theme was the same, however, the presentation was done in an entirely new manner, one could hardly call it infringement, which takes it back to what Vindhya said about the cop movies. There are quite a few cop movies coming up with quite a similar principle, but the way it's represented is what makes it different. There may be new characters, the cop may have a few other features or, so that's what makes it a little different. And wouldn't be considered infringement if you consider the movie as a whole. Now, honestly, I feel like the film industry has really used that fact more than anything, which is why there are a long list of movies, Hollywood movies that are adopted into Bollywood films, such as like Phone Booth into Knockout, Hitch into Partner, Kante came from Reservoir Dogs. And it's a long list, so I think that would be the entire series. But if the work is not a direct reproduction, and this is what is held in R.G. Anand as well, there should still not be a substantial similarity between the two works. To determine whether substantial similarity exists, one must separate the idea from the expression. Again, exactly what Vindhya covered, that the expression of the work is what actually makes a difference. Just an idea anyway cannot be copyrighted. So the way it is represented before the audience, the way content is, presented before any person going through the Instagram user would make a huge difference as to how the work is being represented. So there are quite a few cases within even the Bombay High Court where they really consider this expression of the work as distinctive. So, for example, in Shivani Tibrewala versus Rajat Mukherjee, it was held that if it is proved that the substance or kernel of the plaintiff's work is copied, the same would amount to infringement of copyright. However, what is to be considered is the extent to which it is being copied. If the quality of the work is copied and not the quantity, it wouldn't be considered, infringement. So, which is what the whole substantial test is, that how much of the work is actually copied? Is it to quite an extent? Does it have a different meaning altogether? So those are a few factors that are,
And how do you quantify this, to a substantial amount? Like, what is the, yardstick for measuring this?
So that's what it's honestly case to case, but as has been held in RG Anand, it's, if an ordinary observer feels that there is quite a bit of similarity, if there is, for example, there was sorry, I don't remember the exact song, but there was a particular song where the screen, the screenplay, the song sheet was what was compared in court. How many of the beats are similar? How many beats, is it after one single beat or two single beats? And that was considered for determining whether it was infringing or not. So it's really case to case, but it really depends on if it's a complete copy, a complete reproduction, or, a different variation of something that is similar, but being represented in a completely different way, which is why I feel that phrase, and I feel that would be my last line, that the idea, more than the idea, it's the expression of the idea which should be considered while determining whether it's infringing or not.
Right. Thanks, Sarika. And, with that in mind, what are some of the specific rights and responsibilities that a content creator may have? When you say, say the ordinary observer test, now, as a creator, as a conscientious creator, what should I be looking at while, maybe getting inspired from a story? Or, what are my responsibilities? And then if I feel somebody is infringing, what are my rights?
Right. So first I'll start with the rights bit of it. Now, when you are a content creator on Instagram, honestly, content is being created left, right, and center. There's so many Instagram influencers, these days. I think everyone's becoming one thanks to the lockdown.
Yeah, absolutely.
But so there are there are two umbrellas that I could consider as rights. One is economic rights and one is moral rights. Your economic rights, of course, lead to the monetary bit of it, where, you can reproduce, make copies, distribution of copies of the work, performance of the work in public, broadcasting, anything to the public, adaptation of any work. Those are the rights that you have over the work that you have. Whereas moral rights is that, if suppose you feel that the work that you're creating is being copied by someone, and that the way it's being copied can harm the reputation, can harm your reputation, or even harm the reputation of the work that is being reproduced, or put it in a bad light. That's one of the rights that you have. As far as responsibilities of a content creator, I feel it's really important to do a common law search, as in like a ground check as to what is out there before you create something. Because honestly, Google is your best friend, but just reaching out to legal advisors also with regard to just checking the database, a copyright database, for instance, or honestly, when it comes to movies and TV serials, just seeing if there's anything out there that's similar, that would be a great start.
So if I may just use some example here, just for the sake, to help our audiences. Say we take the example of Three Idiots and Chetan Bhagat, right? He's the writer of a book. Now he creates a book in a storyline, and somebody else wants to make a movie on it. Now, in this scenario, what would you tell the author of the book and the makers of a movie? Like, what exactly do they need to do to show, ensure there's harmony when the product is out?
So I feel like as a first step, it's always viable to get a license in place. If suppose you are, so there's under copyright, there's something called an adaptation. So if suppose you're adapting a work, which is already a book or already a movie into another work, it could be considered an adaptation. It could also be considered a derivative work because it's from a main source of work, it's, being formed into something else and being represented. So a license is always the best way to go because then you can, ensure that you have the necessary permissions in place. You're not stepping on any toes or anything. But I also do get a lot of questions that, I'm putting up pictures on my website and there are thousands of pictures. I cannot sit and take permissions from everyone. It's a cumbersome process. And a lot of it are in public domain, which is it's available to public. There's no copyright over them. So what do? Do I sit and take permissions for everything? So for those instances, I feel it's always good to at least cite the source from where you've taken it, mention the person's name, if necessary, mention if it has a copyright, but honestly, just the person's name from like, if suppose it's even as simple as, if suppose it's as simple as a URL as well, just mentioning that is, covering a basis. It won't save you if suppose the person does decide to come for an infringement claim, but at least the fact that you've cited the source ensures that you're not claiming it as your own. So, that will cover a few bases.
That disclaimer that we see any resemblance is just coincidental. Does that help?
Yes, yeah, definitely. That's something that, again, it's very good at covering your bases because at least you are not claiming anything to your own. It's fictional. It's not related to any party. But, Ashma, I actually wanted to bring up a point, like even with regard to like TV shows. There are a lot of famous TV shows. There are a few popular ones that everyone binge watches. So like Friends is one of them. And most recently Squid Games. So like I've seen like all these fast fashion brands like H&M and Zara have started adopting the, that green and white tracks that the players wear in Squid Games as a design, and they don't really, of course, there's no Squid Games mentioned. There's the prominent number on the chest is mentioned, but that's about it. So even that could be considered for inspiration versus infringement because technically it's not merchandise because it's not really there are no permissions in place really. But I would consider that as an aspect of, inspiration in a way, because they aren't really claiming it's Squid Games or anything, but it's, because it was such a striking color or, because people may want loungewear that looks like that, they've adopted something similar. Of course, I'm sure Squid Games could possibly come and question them for, doing it. But as of now, there are no claims for such adoption.
Right. So we've thrown in an idea there for lawsuit. Thanks, Tarika. And Dr. Pratap, coming to you, like Tarika mentioned, the fashion and photography industry often have a spate of these issues. And oftentimes the creativity comes from fashion or photography trends like Squid Games or something like that, which is popular. So where does inspiration end and infringement begin?
So this is a US case in which a photographer, Patrick Areo, he launched a book called Yes Rasta, which was basically photographs of Rastafarians from Jamaica he's taken. A few years down the line, another artist, a visual artist, Richard Prince, he incorporated these photos in his series of work called Canal Zone. He made a lot of money out of it. All he did was he tainted these images and added a guitar and a few blue circles there on the eye and the face. And there was a court case for this. And what happened was the court found that it is actually appropriation and transformation of the work. But I personally, in this case, don't think the court's decision was right because I think 90% of the image is the same as the original Areo's work. So this is what I think, that it's an infringement work, not actually, just being inspired by. Can you go to the next slide, please?
Sure.
Okay, this is Rogers versus Goons. So basically, this was also a US case law. It's a very important case. And in this, Art Rogers was a photographer, and he took this photograph of a couple sitting there with about 8 puppies. And he titled it String of Puppies. What Jeffrey Koons did was that he made a sculpture out of it. So what he did basically was to change the medium. So from instead of being a two-dimensional photograph or a painting that he adopted, he moved it into a three-dimensional thing and he made a sculpture out of it. But in this case, the court actually found that this was infringing because he just changed the medium from a photograph to a sculpture. Can we go on to the next one?
Sure.
Okay, this is Andrea Blanch versus Jeff Koons. Again, see, Koons has been part of the law there for a very long time. He has lots of cases against him. In this case, the court took a different view. So this was basically a Gucci ad for Allure magazine, in which by photographer Andrea Blanch. And what happened was this photograph he incorporated in another work which is called Niagara. It was an oil on canvas painting, and he basically rotated the image and incorporated it with 2 or 3 different images from different sources.
Mm-hmm.
But interestingly, in this particular case, the court held that this is actually transformative and that he has used the original work as a raw material to incorporate in another work. So in this case, he was able to, there was no infringement case against him. It was considered to be an inspiration and using the word. We go on to the next one. This was a Star Athletica case. The Star Athletica brand, the Varsity group owned the patents for these cheerleader uniforms. And they actually had these copyright for these uniforms. And what happened was Star Athletica started making the same uniform with exact same chevrons and the same zigzag patterns and started selling them at a much cheaper price than Varsity. But in this is a very important case as far as fashion law is concerned. The court found that no, these designs can be patented. Fashion designs can actually be patented. Can we go on to the next one?
Sure.
Okay, so this is the regarding a rapper, Bismarcky, who actually used a sample of another artist's music in his song Alone Again. And this is Grand Upright Music versus Warner Brothers Records. In this particular, case, it was found that these hip hop artists, they have to take permission to get to incorporate these samples of the music. It's a very old case. This is 1992. So in this matter, what happened was the rapper Bismarcky, he applied for permission from the original artists, but the artist did not write back to him. So he used it without permission. And this was the judgment. After that, that was almost mandatory, and everybody has to take, these sample clearance fees has to be paid to the publisher before they can use music from somebody else's work. So these are very old case laws, and now the law has built up on these existing case laws.
And where's India on this?
Yeah, I have one more slide, but which is not available in this.
All right.
Yeah, I don't have it on this. I have it with me right now, but I don't think I have it.
Unfortunately, there's a tech error at the moment, and we're unable to. Would you try again by any chance in case the rights are working? Because we've shared it.
Screenshot of that, and it can be shown. Is it possible?
Sorry?
Can I share a screenshot of that image and it can be shown?
Even then, you'll have to share your screen, but if it's not happening, then I'm afraid it may not be possible at the moment.
On the chat if possible.
Yeah, for everyone else's to watch. Yeah.
So basically, this is what inspiration from my own perspective looks like. The picture on the top left is Wanderer Above a Sea of Fog, which was by a German artist called Caspar David Friedrich. This particular image has been used as an inspiration for many artworks and posters of games and movies. So this is what basically I'm trying to say, that the poster on the right, The Legend of Zelda, it's a very famous game. This is the same theme has been adopted here. There's a single individual in front of a landscape, standing and looking over. Same thing has been adopted for a Star Trek movie, Star Trek Into Darkness. The same theme is just everywhere. There's another art by Hablik. He was an artist. So he has done the same thing, except that he's taken a different perspective from a different viewpoint, the image can be seen. And lately, this has also been adopted into a meme. This has also become a very famous meme with a person taking a contemporary meme, with a person taking a photograph of the surrounding instead of actually enjoying what the surrounding is, what the artist was initially trying to capture. So this is what inspiration means to me, is that this is inspiration. So nobody can say this is infringement, because the theme is there, the idea is there, and ideas, as one of the panelists rightly said, is not copyrightable. So the same idea has been carried on in across 100 and 150 year period, and it is still going on, and this theme is still used by a lot of photographers, to capture the beauty of the environment and to compare that how small the individual is compared to the immensity of the environment and the world.
Right. Thank you, Dr. Pratap. What a wonderful presentation. Thank you so much. Subhash, coming to you and taking from where Dr. Pratap left us with the artwork. Other than that Zelda poster, every time I see The Starry Night by Vincent van Gogh, I feel like, it's being misused by every phone cover, every diary notebook, things like that happen. I'm sure they're not utilizing, the permissions the way it needs to be. So what are your thoughts on this? Where is inspiration? Where is infringement? And over to you.
So I have a lot of merch of Starry Nights. I have a tie as well. So this is something very interesting, like especially in art world and visual arts. A lot of time you would be copying something which is already in public domain when you're talking about Starry Night or any of the Van Goghs. Or in fact, today I was reading that Picasso, one of the museums is celebrating 50th death anniversary of Picasso. So that's a good news for a lot of art connoisseurs, because after 10 years it will be all public domain. So from IP law perspective. So it is very important to fundamentally understand what is inspiration, to how far you can go with your inspiration. When I see somebody using bold colors and geometrical shapes, I would rather perceive it as an inspiration from Raza or Picasso. So it generally happens. It's a tendency that we have, that when we look at something as a layman, as an average intelligence with imperfect recollection, as we use it in trademark. But yes, when we look at something, we tend to compare it with something existing. Now, if that comparison leads you to believe that this is substantially similar, then it is infringement. It's as simple as that. I am not getting into the technicalities of law, but when even the courts, because when we are talking about injunction, when we are talking about infringement, we are also talking about court of equity. Now, courts of equity, they apply subjectivity, they apply their own discretion. They generally apply bundle of tests. It's not in isolation that they would only apply substantial similarity, or they will only apply judgment, skill, labor. They would only apply, say, minimum modicum of creativity or sin law affair. So all these tests are put together to understand whether something is an inspiration or is an infringement, right? It's very important. I was just thinking that as kids, when we were in examination hall, there were invigilators who would stop us from copyright infringement. If I had known about Copyright Act, I would have simply said apply section 52 and it's all educational, right? It's fair deal. I can copy. So what is important is that we need to understand from business, from artist perspective, from creative professionals perspective, that there are as a ground rule, something inspiring could be infringing, but then there are defenses. Defenses could be that it is used for educational purpose. So there are, in art school, you would see a lot of students sitting and looking at a masterpiece and trying to recreate that masterpiece.
Yeah.
So that is an educational purpose, right? When Dr. Pratap just shared a meme, with an art, showing somebody clicking a picture. So that meme is again parody. It's a fair use. So those things are defenses. When I say defenses, these are infringement, which are an exception.
Yeah.
That is very important. It's not that you are allowed. It's not an assertive right. It is a negative right. It is something carved out as an exception under law. So as a creative professional, whenever we are going on Instagram, getting inspired, if we pick that post, that story, we start to replicate, we need to know that you're bound by terms of use or privacy policy and other mumbo jumbos of Instagram. Also, that these work are already existing, they are original, and if you copy anything from it, it will amount to infringement. Now, the subjectivity applies later. The discretion applies later to say whether it is just an inspiration or it is infringement per se. In that case, the court will say, will look at whether it is an appropriation or it's a misappropriation. Whether there is a same lawfare where, like French artists like Renoir and Monet, they used to sit together and paint the same, landscape. So that is where the concept is so merged with your expression that you cannot take it out and it has to be there. So if that is the case, then that would not amount to infringement per se. So for all creative professionals, the takeaway is that that your inspiration should not be substantially similar to existing work. B, get inspired from public domain work, because that's easy. Nobody will have a claim. C, you can use open source, things which is available on Google. So, generally people say that I went to Google, it was easy to, it was available, so I just picked it up. That's not open source. You need to look whether it comes with a Creative Commons license or it's an open source work. These are few things one should keep in mind when they are getting inspired to an extent that it can amount to substantial similarity. And that applies across the board, be it visual art, performance art, or music, or anything.
Right. So coming back to public domain, Subhash, would you call someone's open Instagram account as public domain?
No. See, legally speaking, public domain is publica juris when the term of the copyright is over. So copyright is for a limited term, lifetime plus 60, and it changes from different jurisdictions. But generally, if I say that if somebody has created a work in 2020, then till the time he is alive, and then 60 years.
Yeah.
So that's after that only it comes in public domain. So most of the work of, say, Impression artists or Renaissance artists, they all are in public domain. And that's why you see so many merchandises around.
It's important to let people know that just because someone's opened their content out to public doesn't mean that anyone is free to just download or use it without permission, whether or not they ask for credits.
Yes, that's not public domain.
Right. Thanks, Subhash. And, more on that from Nihal. Nihal, you also, mentioned how plagiarism, inspiration and infringement lines are getting blurred.
Yes.
Would you please take us through that?
Yes, sure, Ashma. So I would like to share my screen. So I would like to throw some light about plagiarism, copyright infringement. So here's an example. So last year what happened was Deepika Padukone and the owners of the famous brand Levi's were trolled for copying. Now here the advertisement, if you see here, the advertisement shows Deepika grooving in a green studio which was alleged to be copied from Sony Tarapurwala's movie Ye Ballet. It was a Netflix original film. Now she even tagged it to be saying that it's a proper intellectual theft. In fact, it was surprising that the production director of the said advertisement went on to say that the director wanted to be the same. But in the entire scene, what caught my attention was the wordings of Mr. Samit Sinha, a managing partner of Alchemist Brand Consulting Private Limited. Now he said that product designer who did the set of the Levi's advertisement should not have taken the director's brief so literally and used it more as an inspiration rather than a replication. Now, copying or plagiarism or copyright infringement is not restricted to a particular field. It is common in all the fields. Now, I would like to take you to this another example where Nora Fatehi was trolled for plagiarism. So here on the social media, when she came up with a female version of the song Pachtaoge. Now it was alleged that it was copied from Beyonce's Mine video that got released in 2014. Now here, when Nora Fatehi replied on the social media, she said that this particular video that was launched was actually an inspiration from different aspects of the society. So the white background or the white clothes signified the purity, love, whereas the choreography and cinematography took an inspiration from the works of popular pop stars Billie Eilish, Zayn Malik, and Madonna. Now, according to me, just because a concept appears to be similar doesn't mean that the work is copied. So, as Vindha ma'am specifically mentioned, that there are no particular criterias to, identify whether a work particularly, is copied or is amounts to copyright infringement. There is no particular criteria. It differs from case to case. So similarly, there was another example I would like to bring to you, that this photograph on the left was taken by Dabbu Ratnani's 2020 calendar, where he was accused of copying an international photographer, Mary Beresh, having a similar photograph. Now here, what Dabbu Ratnani said was, I didn't copy this. This is not my, I haven't been copied. In fact, in around 2004, he had taken a similar photo shoot in which he had of Taboo, actress Taboo. So he said, what my current photograph is, what my current creation is just an addition to my prior work. So that is not, plagiarism. When I'm making an addition or improvement to my existing work, it does not amount to plagiarism. So now the thing is, I'm sure people might be very confused as to what is plagiarism, what is copyright infringement. Oh God, it's very confusing. So yeah, plagiarism has a great impact on creativity. Plagiarism simply means taking someone else's idea of work and passing it off as one's own. So to distinguish between copyright infringement and plagiarism, I would say plagiarism covers thoughts, ideas, formation. So I would like to give reference to these examples. For example, here it's again a matter of perspective, but the concept here. So if there's a concept that is copied, then in that case it becomes a plagiarism. But a copyright infringement happens when there's a copying of material ideas in a material form. Secondly, I would also like to emphasize that plagiarism is committed when the rights of a creator are affected, whereas in case of copyright infringement, it is the rights of the copyright holder that are affected. So plagiarism, to be very frank, is a common offense in education industry, where randomly people or students, to be specific, have copied the concepts without even quoting the sources or giving enough credits. So yeah, but still, though there is no fixed format to decide whether a particular work commits an act of copyright infringement or plagiarism, but still there are certain parameters on basis of which the courts over a period of time have come to decide whether the act is a copyright infringement. So to be here, the first important aspect is what is the purpose and the character. So here, if you see, this is of course the copies of Mona Lisa painting. If you see here, they have just changed the features. Here they have just added a mustache. Now this work, a derivative work, so this won't amount to a copyright in itself, because just a mere addition does not make the work unique. But on the other hand, if you see the first image, here the artist, though they are copywriting the Mona Lisa, it's an original picture that they are creating with their skills, by using their skills and their efforts. So here they will be entitled to a copyright protection even though it is a Mona Lisa painting. And here the act will not amount to plagiarism. Now the next important facet is nature of the work. What is the nature of the work for where a person is accused of committing act of plagiarism or infringement? Then is the amount and the substantiality of the portion for which the act is committed. So I remember here instance, so the rapper singer Badshah was accused of committing plagiarism over his recent song Genda Fool, starring Jacqueline Fernandez. So he used certain verses of Genda Fool, a popular Bengali folk. Now here he was under the impression, is what the sources say, that he was under the impression that it is a folk song, so okay, chalo, let's go ahead with it. But he did not realize that okay, there's a creator. Even if the work is not within the purview of copyright, there is something called as plagiarism, for which he actually later reportedly deposited rupees 5 lakh in Ratan Khan's account as a gesture of, as a recognition for his work and his creations. So that was an interesting act where, plagiarism came into a play. Then there's this another important aspect is that the effect that a particular work, whether it's infringed or plagiarized, will have on the potential market. Now, when a particular work is done where an infringement or plagiarism is committed, people tend to forget the impact that it would have on the creators. It is the fact that they forget to realize that there have been just lot of sweats and skills that have been involved in creating a work. So I would say that whenever people tend to take an inspiration from work, see to it that you tend to give recognition to the source or recognition to the creators. Appreciate them for their work, because after all, everybody here is working hard ultimately to get appreciated for what they do. So I think that is one of the important facets that everybody should remember. Then now we have talked a lot about infringement ye hota hai, then there's plagiarism, but doing certain acts or undertaking certain acts do not constitute infringement or plagiarism. Or so I would like to bring into light the doctrine of fair use. Now, for example, so if reporting for current events, then in such cases using any material for reporting events is considered in public interest and comes within the purview of fair use. A criticism or a review, a purpose for judicial proceedings or to report judicial proceedings, certified copies made in accordance with law, bona fide use for work of educational purposes, reproduction for private study. If I take a particular material from the internet and I've been using it for my private study, then it won't amount to copyright infringement, but rather is a fair use until the time I decide, okay, I'll take the copies and I'll start exploiting the work. Making it commercially exploited or exploiting somebody else's work without permission will amount to plagiarism, and if the work involves copyright, then it would amount to copyright infringement. So
Right.
yeah.
Right. Thanks, Nehal. So just to write their thesis and they're doing their work, copying
Yes.
maybe from various authors. What would you say needs to be done in that time to ensure that they're not plagiarizing their own text or thesis?
Yes, so Ashima, as I mentioned that in field of education, plagiarism is very common. So yeah, in order to avoid plagiarism, it is necessary that a due credit is given to the owner. Ensure that the citations are written properly. students need to be very clear with their citations. Give proper credits to the owner of the work, even if the work is in public domain. Never should student use phrases without quoting the person who has, said it. Nowadays there are several plagiarism check tools which I believe everybody can use.
Yeah.
Some of them are free, some of them are paid. So you can check the plagiarism tools, you can understand the amount of plagiarism. The idea behind everything is that the person should understand that so not everything that is available on the internet will expressly say that the work is entitled to copyright protection. So even you have to ensure that the work is not licensed. Does it come under the purview of copyright? Even if it doesn't come under the purview of copyright, still I would suggest that the student should quote the source, because it will they should give the credit for the original work.
Right. Thank you so much, Nehal. Very quickly, I know we're up one, but very quickly taking last comments from our panelists, starting with you, Subhash. As we wrap this conversation, what would be your last word and message to content and artwork creators?
Something I missed, talking about was disclaimer. It's a sham. So, don't put a disclaimer where you know that you have intentionally copied something, because as the law stands, if something is done intentionally, then along with the injunction, you have to pay damages. But generally, people use disclaimer just to say that, I have not copied. You tell me, I'll remove it. But till the time, you still are, somewhere liable. From art perspective, from visual art, photographs, it's across Insta, all the social media. It's important that you should know what are different exceptions under infringement under 52, which allows you to take photographs. Say if you are in public domain, you like some murals, you're traveling through Lodi Art District, you take pictures of the murals and paintings. That does not amount to infringement. That basically it's an exception. So for artist perspective, but yes, if you have taken a picture and you replicate it on oil on canvas and start selling, that is an infringement. So you need to know that.
So long as you're not selling, that's fine.
Yes. Say Copyright Act is not, it does not say limit only to course of business. It does not limit to making profit. It is anything which is copied can amount to infringement. So that's also important to know. Other than that, yes, whenever you are taking a photograph and obviously if it's on Instagram, there is an implied license that can be used for private purposes. But of course, as an abundant caution, you can credit or you can just hashtag or, just do the @ sort of thing just to give a credit. So those are small things that you can do. Largely, you should not copy something substantially and adapt it in a manner that it amounts to appropriation, just like Roger versus Goons case, where a 2D photograph has been adopted into a 3D sculpture. Yeah. So that is something that you should not do. In fact, we were doing a matter and we actually compared the two artworks by using compass and all those geometrical tools to show that how there is substantial similarity to that extent. So it is important that you don't copy. You can copy the concept. The idea is not protected unless it's a trademark, like the GSM idea. So you can continue to be inspired, use the concept, use the idea, but don't copy the same expression. That's important.
Right. Thank you so much, Subhash. Dr. Pratap, over to you.
I would just suggest that I think it's best for content creators to take. There are so many subscription services that you can actually subscribe to, ranging from 1,000 to 3,000, 4,000 a month. And you can get, without copyright-free videos, high-quality 4K videos, pictures, images, audio, music, everything. So I think it's best to avoid dealing with the lawyers than to, get yourself. I mean, no offense to all my colleagues here, but I think it's best, a couple of $1,000 you can get a subscription service which will provide you all the content you need, and you can do the editing and whatever you want to do, keeping in mind that you are, transforming the work enough so it will not, end up in the courts. I think that is what
Thank you. Thank you so much, Dr. Pratap. Tarika, over to you.
So honestly, all I'd like to say is that, as humans, I think it's very possible that a lot of us can come up with the same idea and, represent it. I mean, there's a lot of, inspiration around us. There's too many avenues available for that. But as I'd mentioned, the best way to avoid getting into any of these hassles is by checking every aspect before, putting in that effort of creating something or before publishing something. Checking for copyrights data is honestly like a few clicks away. So it's very important to do your groundwork and your check. It's very important to do your groundwork before actually, thinking that you've come up with something really unique. It's always best to cover all those bases.
Right. Thank you so much, Tarika. Nehal, your thoughts, please.
So, Ashima, I would just conclude by saying, there is nothing wrong in taking inspirations. Each and every one of us at some point of time has taken inspiration, has been inspired by works of people, whether it be in our field or somebody else's field. But what is important here is to understand that not to create a work that is a copy of somebody else's work. Take inspiration, take ideas, develop your own work, use your own skills, and if possible, try to understand, try to detect the source from where you have got the ideas. Give credits for your work, and yes, stay safe.
Thanks, Nehal. Linda, over to you for your last word.
Thank you, Ashima, and it was a wonderful presentation by all the speakers, and I'm very honored to be part of this discussion. Since everyone else has addressed, what content creators should do to prevent a copyright infringement, I just thought, I have some advice to people who are creating original work and who are trying to enforce their copyright. And, my advice would be, don't look at just copyright. Look at trademarks, get your, artworks, photographs can be trademarked, your logos can be trademarked. And, sometimes it's easier with trademark infringement, it's easier with design infringement rather than copyright, because we've seen the amount of subjectivity that copyright infringement actions bring in. Trademarks, much more straightforward, designs, much more straightforward. So when you're creating anything original for your business, for your work, think about all kinds of IP, contact a good IP lawyer, it's worth the effort that, you wouldn't have to take at a later stage trying to defend difficult copyright matters. Be smart about what your work is and how you're going to try to protect that. Thank you.
Right. Thank you so much, Linda. Audiences, if you have any questions, any more questions for our experts, please write to me at ashima@businessworld.in. We'll take them to our experts and get you your answers. Thank you so much, panelists, for this enlightening discussion. This has been so wonderful. Thank you all for joining us today, and happy weekend to all.
Thank you, Ashima.